Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm here with my apolitical co-host, Brett.
Absolutely, Alice. Always. That's one of our things about this podcast is we don't delve into politics. And we're not going to delve into politics today. We're going to do an entirely legal topic.
That's right. That's absolutely right. And that's actually a really good distinction because there are ways to talk about the law and about important legal decisions that have major ramifications on our political system without getting political. And the reason we wanted to cover this, recognizing that some people are just going to immediately want to skip past it. They don't want, political fighting. But here's the thing. This is a very important issue for every single person who lives in the United States and it plans to vote or otherwise to understand, because this is not meant to be a political fight. And of course, we are talking about the Trump versus Anderson decision from the Supreme Court that came out this week. And looking at just the result, and we'll delve into the facts that led up to this, it was a 9-0 decision. You may hear that a lot, 9-0, 9-0, 9-0. The United States Supreme Court is made of 9 justices, and you kind of call the votes as you see them. So 9-0 means it's a unanimous decision. And I mean, there are appointees by both Democratic and Republican presidents sitting on the court now. And we've talked about this before. The majority of opinions coming out of the Supreme Court actually are 9-0 or unanimous. And this is one of them. But there are some interesting concurring opinions. But before we get too far, let's back up. And don't worry, this is not going to be a political discussion. We're not going to talk about who should be president. None of that really matters. What matters is, what does the Constitution say?
And this is a really interesting one because you get to dive sort of into history. And I would say everybody should read this opinion because it's a really good example of interpreting the Constitution using the historic context. And you see that from both sides in this. We typically think of the Supreme Court like we do everything else in terms of politics. Currently, there are 6 justices who were appointed by Republican presidents. There are 3 justices that were appointed by Democratic presidents. And sometimes you see that sort of political breakdown, and other times you'll see sort of unique alliances between the justices when they're deciding these cases. But in this case, like Alice said, you're going to have this 9-0 opinion, but you have sort of a majority of the majority, and then you have a couple concurrences that point out a few things. And it's interesting to see how they view the constitutional text in different ways, even though they're reaching the same conclusion. So what are we talking about here? So for those of you who maybe you're not from the United States, or maybe you just don't pay attention to this stuff because, frankly, you got better things to do in your life than deal with the constant political warfare that we have in this country. So this is going to be about the Constitution. And it's about whether or not a specific provision of the Constitution prohibits certain people from being president. So I'm going to read to you the provision so you have it in the back of your head. And then we're going to talk about what happened over the last few years that got us in front of the Supreme Court. We're talking about the 14th Amendment to the Constitution. This is one of the most important amendments. It may be the most important amendment in the entire Constitution. So, real brief historical rewind here. Before the Civil War, the American Civil War, which lasted from 1861 to 1865, the states were very powerful and were sovereign in a way that's much greater than what we have now. And in fact, they were so powerful that the United States Supreme Court had ruled that they could deny basic human rights to certain people, that if you were a slave, you were not a citizen of the United States. You could not even avail yourself of basic protections by the Constitution. And the southern states, which were the slaveholding states, they had slavery, right? So that's a pretty fundamental distinction between where we are now and a great power that those states had to enslave entire groups of people. Well, after the Civil War, after millions of people were died or wounded or displaced, the slaves were freed. Everybody kind of came together and said, look, we want to make sure this doesn't happen again. And it seems like there's a fundamental flaw in the Constitution. It empowers the states too much. States can't be able to do this. They can't be able to deny basic rights. So what you think of as the Bill of Rights, for instance, that applied against the federal government. If a state wanted to have a state religion, they could. If a state wanted to abridge your First Amendment rights, they could. If a state wanted to ban all firearms, they could. At some point after the Civil War, when they started talking about this, the idea was, let's pass an amendment that applies all these basic rights and protections against the states. So the states can no longer do this. Let's pass an amendment that makes it very clear that anyone born in these states is a citizen of the United States, which directly overturned Dred Scott, which is a case we should do at some point, just because it's fascinating, both for its historical aspects and just how horribly wrong it went. So they overturned that. But another thing they did was they said, look, we have all of these people who engaged in a rebellion against the United States, who took up arms against the United States. Many of them were in the United States military. Many of them were judges and senators and Congress people. They took oaths to uphold the Constitution, to defend the Constitution, and then they made war against the United States. What we don't want to happen is for Alabama, for instance, to just send all of these Confederates back to D.C. as sort of a rebellion in power, just sort of holding up everything in Congress. So we need to have a way to stop that. And part of that was Section 3 of the 14th Amendment. And here's what Section 3 says. No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath, is a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So that's Section 3. Section 5 says, the Congress shall have power to enforce by appropriate legislation the provisions of this article. So the ones that I talked about and Section 3, Congress has the power to pass laws, basically saying, how are we going to enforce these aspects of the 14th Amendment? And Congress can actually lift this restriction, and often did. It turned out there were a lot of people who had served in the Confederate Army or in Confederate politics who ended up serving in Congress, several of them speakers of the House. It was sort of remarkable how things went after the Civil War, given how bad it was. But that's the provision. And that provision became at issue after the 2020 election and some of the things that went down in the wake of that.
Right. So that's the history of how the 14th Amendment and Sections 3 and 5 came to be. So why does that matter today? So those of you who may not be in the United States, we are currently in primary season in an election year, and it is part of the 4-year election cycle to elect our next president. So a group of Colorado voters argued that Donald Trump, by inciting the events that culminated in the January 6th breach of the Capitol building during the ratification of the 2020 election, engaged in insurrection and thus was ineligible to hold federal office. The Colorado State Court found that Trump had engaged in insurrection, but found that the office of president is not covered by the 14th Amendment. In a 4-3 decision, footnote, we just talked about how there's 9 justices on the U.S. Supreme Court. Each of the 50 states have their own Supreme Court, and the numbers of justices on each Supreme Court can actually vary. So in a 4-3 decision, so a close decision, the Colorado Supreme Court reversed, finding that the president was an officer under the United States and barred Trump from the ballot in Colorado. So note, we had been talking about the 14th Amendment, which is from the federal Constitution. The judicial activity that we just talked about here is all happening in the state court of Colorado. Not a federal court, a state court. Now, Supreme Court cases, especially this one, can be then appealed up to the United States Supreme Court, which happened in this case. And they had to determine whether the Colorado Supreme Court was correct in its decision in finding that Section 3, or at least the 14th Amendment, allowed Colorado to bar former President Trump from the ballot. Now, the United States Supreme Court focused not so much actually on Section 3, which is with the insurrection language, but on Section 5, the very short sentence that said power is given to Congress to enforce. And generally speaking, the provisions of the 14th Amendment have been given effect by enabling acts passed by Congress. And in fact, Congress passed an enabling act to enforce Section 3, the Enforcement Act of 1870, to govern how the amendment applied to federal offices. The court held that this division of power continued here. The states could disqualify from state office, but they could not disqualify from federal office, especially the presidency.
Yeah, so you have a situation where, and this is often how these things go, that, and we talked about this before, that as you move up, the issues that are important to the particular court change, and the bases on which they can make their decisions can change. So, the Colorado courts, number one, they're figuring out whether or not this was an insurrection, whether or not, if it was an insurrection, Trump was engaged in the insurrection. And if he was engaged in the insurrection, does it matter? Does the provisions of the Constitution even cover him? My dog is being a very poor co-host. Are you going to have to go downstairs? Huh?
Then he'll be a vocal co-host from downstairs.
Come right here and lay down next to me. Down. Go ahead. Okay. You can stay right there. I'll pet you. Just relax.
That dog needs some Xanax.
He does need some Xanax. So anyways, in making this decision, the initial state court basically said, well, yeah, I think it was an insurrection. I think Trump's actions made him an insurrectionist. But I don't think the presidency is necessarily covered by this provision. And that's not an easy question, because the way it's written, it does not specifically say the president. It says this language of hold any office under the United States or as an officer of the United States. But the strange thing is, it specifically talks about executive or judicial officer of a state, but it doesn't talk about the executive officers of the United States. So one thing you could wrap yourself around if you wanted to is the president an officer under the United States or not? Or is the president sort of, because the president stands alone with his own article of the Constitution and everything else, maybe somehow he's not under the United States? That was what the state court got wrapped up in. Supreme Court's going to dodge that question altogether and go straight to enforcement. So then it goes up to the Colorado Supreme Court. Colorado Supreme Court says, yeah, we're going to say he is an officer and we're going to move forward. And like Al said, it was a close opinion. You had one of the dissenting justices say, look, this is a complete waste of time. This is just going to get reversed. Why are we even doing this? But that's the thing. It's a majority vote, and that's the way the majority went. And so then it goes up to the United States Supreme Court. And the court is going to say, essentially, Congress has to pass some sort of law about this. Congress has to deal with this. States can't deal with it under their own power. And why is that? Well, as a general matter, the Constitution delegates power to the federal government from the states. So the federal government is one of enumerated powers, while the states have general powers. So we often talk about the police power. The states have a general police power. The federal government only has the powers that are specifically enumerated in the Constitution. That's one of the limitations on the federal government. It's the reason, for instance, why the federal government just can't make things illegal that are illegal in the states. You can't just have a general murder statute under the Constitution. You have to tie it into some other federal power. So, for instance, if you murder a federal official, well, then you have a federal hook. If there's some sort of interstate commerce nexus, then you have a federal hook. But just your standard murder, there's no federal power to even reach that because it's not enumerated in the Constitution. So generally speaking, the states... go ahead.
Sorry, and remember why this is the case. Remember, we started because we left a monopoly... monarchy.
What?
Very different things. And this is because the foundation of this country is that we left a monarchy where there was an all-powerful crown who dictated everything, and there was no due process in the views of the pilgrims who came over and ultimately decided to revolt the American Revolution, right? And so there was always this fear of a strong central government, which is why the federal government had these enumerated rights rather than this broad general power. Because at the time, and Brett said this at the very beginning, before the Civil War, the states really were little fiefdoms. They were little countries in and of themselves. And then we tried that. It didn't quite work, IEC, the Civil War. And that's when the federal government began to realized that it needed to pass certain amendments to kind of keep everyone in line and not have the Civil War happen again. So that is still the case today, though. We still have a federal government with enumerated powers.
Right. So ordinarily, the states are going to have much broader powers. The federal government's going to have much smaller powers. But when it comes to federal office holders, this is reversed. Then the states only have the power to regulate federal offices or federal elections to the extent the Constitution grants them that authority. A few years ago, there was a question of how you draw districts, and the Constitution gives some broad parameters on that, and some states wanted to do it in a certain way, and it went all the way up to the Supreme Court, because the question was, can a state just do it however they want to? And the answer was no, they can't. It has to follow how the federal government has set it up, because we're talking about federal officials here. And this is sort of a part of that. And nobody argues, for instance, that states could remove a federal office holder once elected. Nobody thinks that a state could do that, or withdraw the electors for a presidential election after the votes have already been cast. This was an attempt to do sort of a more narrow thing and just say, look, okay, obviously, once they're elected, they're then a federal office holder. We have no power over them, but can we say we won't put them on our ballot? I mean, that's sort of the narrow question that Colorado is trying to ask. The problem is, this is the absolute worst place to ask it, because, as we said, the limitations on the state's ability to mess with the federal government, the way it runs, its rights, responsibilities, and everything else, is particularly limited by the 14th Amendment. The 14th Amendment, as we said, radically shifted power away from the states to the federal government. And it's frankly nonsensical to believe that at the same time, the 14th Amendment gave this massive power to the states to restrict who can run for federal office. Think about how this could have been used. Now, we just talked about, why did they even want this? One of the reasons they wanted it was to ensure that all of these sort of unreconstructed Confederates couldn't just all pack the House seats from the South and come to Congress. But if the petitioner was correct here, then you would have had the power in the southern states after the Civil War to simply ban pro-union Republicans from the ballot. And that is obviously not what you're trying to accomplish here. But if the power rests with the state to interpret this constitutional provision and to apply it as they see fit, then you're going to run into that problem. And in fact, no state had ever exercised this power before, even in the wake of the Civil War, when you had many former Confederates successfully running for office. Rather, states disqualified people from running for state rather than federal office. And as the concurring justices wrote, so Justices Sotomayor, Kagan, and Ketanji Jackson wrote, Section 3 marked the first time the Constitution placed substantive limits on a state's authority to choose its own officials. Given that context, it would defy logic for Section 3 to give states new powers to determine who may hold the presidency. So I think one thing everyone needs to understand, no matter how you feel about this, no matter how you feel about Trump, no matter how you feel about January 6th, no matter how you feel about anything involving the elections, one thing that is abundantly clear is that all 9 justices together unanimously just crushed the Colorado Supreme Court. There was no question that the Colorado Supreme Court got this entirely wrong. And none of the justices across the spectrum, from the ones that President Trump appointed to the ones President Biden has appointed, and everybody in between was willing to say anything other than, as the concurrence says, that their opinion defied logic. It didn't even make sense. So that question of, can a state on its own decide to remove someone from the ballot for the presidency is definitively answered for now and all time. No.
And note, so there can be different ways that opinions are issued. This is a per curiam opinion, which just means it's the opinion of the court. It's not the opinion of a specific justice in this case. So a lot of instances you'll have like the majority opinion, authored by Chief Justice Roberts, and then concurrences and dissents, whatnot. This one, it's not a signed opinion, it's unsigned per curiam. So this is the position of the court. We'll talk about the concurring opinions in just a moment, but the votes are all in. Now, all of this, the court found, would be particularly problematic for a presidential race. At least with a race for the House or Senate, one state could have rules for its own candidates that wouldn't affect other states. Maybe Colorado really doesn't, it thinks one of their Congress nominees is candidates for Congress. Today's one of those days. I'm going to play a game of Monarchy later. For example, Colorado may have, an open position for Congress, and one of their potential candidates is what they call an insurrectionist. You can imagine, well, that particular opinion is going to be limited to just Colorado. Not here. We're talking about a race for the U.S. presidency. So the court explained, quote, conflicting state outcomes concerning the same candidate could result not just from differing views of the merits, but from variations in state law governing the proceedings that are necessary to make Section 3 disqualification determinations. Some states might allow a Section 3 challenge to succeed based on a preponderance of the evidence, while others might require a heightened showing. Certain evidence, like the congressional report on which the lower courts relied here, might be admissible in some states, but inadmissible hearsay in others. Disqualification might be possible only through criminal prosecution, as opposed to expedited civil proceedings in particular states. Indeed, in some states, unlike Colorado or Maine, where the Secretary of State recently issued an order excluding former President Trump from the primary ballot, procedures for excluding an ineligible candidate from the ballot may not exist at all. The result could well be that a single candidate would be declared ineligible in some states, but not others, based on the same conduct and perhaps even the same factual record. And this makes complete sense because remember, the original charge of the January 6th insurrection claims were brought in state court under state law. And we talked about this in all of our state court cases, which honestly, when we're talking about true crime, murders, rapes, they're almost always going to be state cases. There are state laws. A lot of them may look like each other, but not so. When you have a 50-state survey of all the different laws in the 50 states, they have histories of why the laws are the way they are. They have different standards. They have different evidentiary rules. And that's what the court is saying here. You could potentially have unequal outcomes across the board on 50 states. So what if 25 states declare that former President Trump can't be on the ballot, but then the other, 25 allow it? I mean, what does that even mean? How can that possibly be? This was the type of kind of unequal outcomes that the Supremacy Clause was meant to address.
And I mean, let's be clear here. If anybody out there who thinks that the various states can come up with reasons to say that various candidates they don't like engage in insurrection through some sort of activity, they could. If the states had the power to do that, they could do that. And you can imagine the results that you would have. And what's interesting
It
when you
would be
look at this
political
opinion,
warfare, right? Like, I mean,
yeah,
truly,
absolutely.
it would be
A
politics
civil
and
war, maybe.
it would be, I mean, really, it would be. I mean, there is nothing that would prevent, and really, unfortunately, what we would see is like the red states would have no blue nominees on the ballot and vice versa, right? I mean, it really would become just like a crazy situation.
Well, and if you look at the election of 1860, Abraham Lincoln was not on the ballot in any slave state, and in fact got no votes in any slave state. And what you don't want to see is a world in which groups of states are sort of banning various people from their ballots, and then I don't even know what would happen. I mean, like Alice said. And what's interesting about this opinion, and when you read it, you see sort of three different layers of argument that the per curiam opinion is making about why they're reaching this decision. The first is textual. So you have the provision. Section 5 says Congress will enforce it. Congress didn't pass a law saying that it's going to be enforced in this way, therefore it can't be. It was like a pure sort of textual argument. Then you have sort of going through the history and tradition of this provision, how it's been applied in the past, how it's been interpreted in the past, the fact that it's never been interpreted like this, which is always a bad sign when you have a 150-year-old provision and nobody's ever interpreted it this way. You know, and it's not like you didn't have opportunities. But George Wallace ran for president, okay? I mean, George Wallace probably was engaged in insurrection at various times. Various members of Congress have been members of the Ku Klux Klan, which is a domestic terrorist group. So you very easily could have applied this in a lot of different contexts to prevent a lot of different people from being able to run for various offices. But we've never done it before. So the historical approach is another thing. And then the practical approach. And if you go all the way back to our interpreting statutes and interpreting constitutions, the different ways you can do it, this is the purely practical. If we interpreted it this way, if we allowed Colorado to do this, chaos will ensue. And so you have these multiple levels, and you can agree with any one of them, or you can agree with all of them, but they all lead you to this same place that the court's trying to get you to. So this is the per curiam opinion, which is the opinion of the court. 5 justices endorsed this reasoning in full. The other 4 justices agreed with the result, but got there in different ways. And Justice Barrett wrote that while she agreed the states could not enforce Section 3 against presidential candidates, she wasn't certain that congressional action was the exclusive vehicle for enforcing Section 3 in all cases, in all scenarios. And essentially what Barrett was saying was, I'm going to exercise some judicial restraint here. This issue isn't before us, so let's not address it. We can deal with this issue just by saying the states can't do it in this particular instance. We don't have to go so far as to say it must always be the result of a congressional law enacted under Section 5. So since we don't have to get there to decide this case, we probably shouldn't. And that's a pretty common rule when judges are making decisions, is keep your decision limited because you can't anticipate all the possible things that could happen in the future and in the specific factual patterns that could happen where people may have better arguments about why this should be a case where, despite everything we said here, in this instance, they can be kept off the ballot. And she's basically saying, let's deal with that issue when it comes up. But, you know, since the only issue here is the president and whether states can do this on their own, let's leave it at that. And that was sort of her position. And then she reiterates at the end, the only thing that really matters here is we all agree states can't do it.
And I really love that. I mean, look, we've always said that all opinions, all judicial opinions, especially Supreme Court opinions, should be accessible to the lay people. And I do like that Justice Barrett is kind of going down this path of, judicial restraint, which might be kind of more of a legal concept that might not be accessible to the, broader public. But she brings it all home at the very end. She says, for present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. To say, I'm having this professorial, by the way, she was a professor, professorial discussion over here. But in terms of what we're talking about today, this is a 9-0 decision. It's me, isn't it? Okay. Now, there's another concurring opinion. Justices Sotomayor, Kagan, and Jackson also wrote a concurrence based on the idea that the majority opinion decided questions that were not before the court. The concurrence wrote, quote, "In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot on the ground that he is an oath-breaking insurrectionist, and thus disqualified from holding federal office under Section 3 of the 14th Amendment. Allowing Colorado to do so, we agree, would create a chaotic state-by-state patchwork at odds with our nation's federalism principles. That is enough to resolve this case." So these three justices also suggested that there might be other means of federal enforcement that could preclude a candidate from running for office, and they feared that the court had inadvertently closed those doors as well. And so it's another way of kind of arguing what Justice Barrett was arguing, which is that the majority opinion went too far, didn't have to say in that Section 5 was the only way to enforce Section 3. All we need to hold here, Section 3 cannot be enforced by the states.
And what is amazing about this concurrence is they could not have stated the issue more clearly and bluntly. Like, let me reread you what Alice just read you. This is the way they present the question before them. In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot on the ground that he is an oath-breaking insurrectionist and thus disqualified from holding federal office under Section 3 of the 14th Amendment. I mean, if
Yep.
you're on Colorado's side, that's exactly how you want them to describe the question, because you're like, yeah. In fact, Colorado probably wrote that as the question presented when they showed up in front of the court.
And let me
Oath-breaking
just
insurrectionist.
let me just reinterpret what Brett just said. What they're saying is that Trump is an oath-breaking insurrectionist, and even so, he is allowed on the ballot.
Yeah, I mean, this could not be a more powerful rebuke of the Colorado Supreme Court. It really couldn't. And that is just, like I said, if that was the first line, if you're Colorado and the way, the Supreme Court, everything they do is Byzantine, right? So you can't get the opinions online when they're issued. If they literally would have people, all the press would be set up in front of the court, and they'd have these runners. I don't know if you guys have ever seen them, but they're like interns for the news organizations, and they would be waiting in the clerk's office to get paper copies of the opinion. And they would take the copies and they would go running out to the front of the court to the media waiting there, reading it as they go so that the media could report. If you guys remember the Affordable Care Act,
I was just going to say.
Yeah. They actually, the initial reports from the press was that Obamacare had been struck down because on the first question, whether or not the Affordable Care Act violated the Commerce Clause, the court said yes, which was a huge deal that nobody pays attention to anymore. I mean, it was like the most crazy Commerce Clause decision to completely reinforce the Commerce Clause, limited the power of Congress in all these ways. And so everybody thought, well, they have struck down Obamacare. But then if you kept reading like 50 pages in, you say, oh, wait, they called it a tax. So they said you can't do it under the commerce power. We're limiting the commerce power, but you can't do it under the taxing power. And so that's the way they would do it. So like if you're the Colorado guy, like waiting outside, and here comes your runner running down with the paper, and you grab the paper and you turn it open. If the first line had been, the court is called upon to decide whether this oath-breaking insurrectionist is disqualified, you would be like, yes, we're going to win this.
I win. I
mean, this is like the ultimate Iron Man. People talk about straw man arguments. This is like Iron Manning the argument, just giving it the most charitable interpretation possible, and then saying, and even with that, you still lose, which is what they did. But they didn't like the fact that the court went as far as it did. Now, what this means, what the three are trying to say, and how one might enforce Section 3 without congressional action is a little murky to me, at least. They suggest an example might be, quote, when a party is prosecuted by an insurrectionist and raises a defense on that score. This, of course, would come with its own problems. It's difficult to imagine if you've got not a state, but a single litigant or a single judge could invalidate, say, an entire regulatory scheme or legislative enactment because the president who signed it was an insurrectionist and therefore not eligible for office. that seems pretty extreme to me. It's hard to imagine the court would ever go along with that interpretation, though I think they're just saying, look, we could decide that later on. We didn't have to decide it now. I think the more likely way you would see it is there is an insurrection statute. I mean, it's illegal to raise an insurrection against the United States. It's not surprising to anyone. I think anyone convicted of that would be precluded under Section 3. I doubt the Supreme Court would say that would not count as arising under Section 5. So I don't think you would necessarily need a specific statute for every single instance of insurrection, but I think you would at least need that kind of federal prosecution in order to get under this. So that is the opinion of the Supreme Court.
There you have it. So, 9-0
Yeah,
decision.
easy peasy.
Hope you, it's only 20 pages total with all three opinions, the per curiam, the 1-page Justice Barrett concurring opinion, and then about a 5-page 3-justice concurrence. Not hard to read. Great history lesson, like we said, and you should read it. You should see how the justices disagree with each other in writing, and it is not, kind of claws out fighting. I think it's a discourse that is kind of lost in the news. So if you found this interesting, we'd love for, to hear from you. If you think we got anything wrong or you have additional questions from this, we also welcome those as always. Brett, anything else you want to add about Trump versus Anderson? Who's Anderson? Answer that for the people.
Anderson, I believe, is the Senate minority leader in Colorado who is a Republican and a Republican elector for Colorado. So in these cases, you always have a plaintiff, and usually it's someone who is kind of set up to be the plaintiff for a test case. I mean, this is a test case, essentially, to get to this point where we're going to find out what the Supreme Court says and how they interpret something. So that's who Anderson is, just an ordinary person. I'm going to give away my book idea. So if you're listening out there and you're a legal scholar and you want to write this, I always thought it would be fascinating to have a book that basically was biographies of the people in the names of famous cases. So who is Marbury? What did he do? Who is Brown? Who is Plessy? Who is Ferguson? Who, just all these people. I think that would be fascinating, because in the United States, every major case, like we call Brown versus Board of Education, it's just referred to as Brown, right? Or, Miranda or Strickland. I mean, just these cases, they stand these names. They're the names of ordinary people. And I thought it'd be fascinating. So,
and then oftentimes, like here, it's not actually the person behind it, right? It's not like Anderson was like, insurrection us, keep him off the ballot. He's just like a public official who's a stand-in. And oftentimes it'll be like the Secretary of State who's going to be on the other side of whatever case that goes to the Supreme Court. So you'll see a lot of like the same name over and over and over, because the Secretary of State is the stand-in for that particular state whenever they have these sorts of suits.
And before we get to questions, I will say one thing on my soapbox here. I love the law. And it bothers me when people use the law for political ends. And let me just tell you, no serious person thought this would go any way other than how it went. And in fact, no serious person thought it would be anything other than 9-0. My wife and I debated, is it going to be 9-0 with an opinion writer or per curiam? And they ended up going per curiam, which is basically their way of saying, this isn't even worth having a majority opinion. But that didn't stop a lot of people out there in the press, the legal press, from trying to convince everybody that this was some sort of complicated issue and they could go one way or the other. And a lot of those people are very smart. There are people that I have a lot of respect for in a lot of ways, but politics makes people crazy. And you always have to remember with the Supreme Court, there is an element of political jockeying and attempting to influence the justices through the press. And you see that a lot. And I think there was an attempt by the press to convince the justices, no, it would be fine if you said Colorado got it right. But that was manipulation at best. No serious person thought it was going to go this way. So I would just caution you, as always, when you have these legal questions and politics is wrapped up in them, just be careful, because a lot of times what you're reading isn't a sober reflection of the law. It's really a political campaign ad wrapped up as a legal opinion piece. And that's just a problem really throughout the legal press these days.
I think that's very well said, Brett. With that, do we want to answer some questions?
Let's do it. Okay, let's see. So these are legal briefs questions, right?
Oh, yeah.
Remember, you go to the front of the line. I'm scrolling through hundreds
If you
of
leave a
questions.
5-star review, either at the
5-star
Prosecutors
review.
Pod or Legal Briefs, but Legal Briefs is the fast pass.
That's right.
Because we just have fewer questions over here at Legal Briefs. We will answer your questions. And people even edit their questions and get more questions. And you know what? We take them all. It's fine.
We love cheating. If you ain't cheating, you ain't trying. Right? I'm a NASCAR fan.
Stop.
Right? Anyway, so I just want to acknowledge this question from Trivia Man, because I'm not going to mark it red yet, because eventually we'll answer your question. But Trivia Man wants to know, what are your thoughts on John Hassner's 1995 essay, The Myth of the Rule of Law? And I got to say, I consider myself an educated person, but just random essays from 30 years ago, I don't know that I have an opinion. I'll have to read that one and get back to you. But I
think
appreciate
maybe you should
the
edit your
question.
question and explain maybe why it's so important to you, and then we can answer it correctly. Only because, by the way, legal academia is like unlike any other academic field. We're not peer reviewed. Like it's usually just a bunch of law students editing articles from professors and professionals in the field on some niche area of law that actually has no practical applicability in the law. So just know that we're not making light of it. It's that there are so many articles, and most of it's not even peer reviewed, and mostly they're not meant to be practical. They're meant to be esoteric questions, esoteric discussions of theory.
So True Crime and Cats wants to know, do you get time to wind down after a long trial, or is it right back to the next case? If you get a break, what is your favorite thing to do to relax after a big trial? Generally speaking, if you're working on a big trial, well, it depends on your office. It depends on the caseload. It depends on a lot of different things.
The day off.
You definitely get the rest of the day off, but you can usually work out, maybe get a vacation. If you're trying to plan your vacation, doing it after a long trial is probably the time to do it. Most trials aren't long, though. Most trials are a day, 2 days, 3 days, week tops. The trials you guys all watch and pay attention to, those trials are a lot longer than your average trial. You could go down to any courthouse in America on a Monday, sit through, well, you can't really sit through it, but there's jury selection. Once the jury is seated, watch the whole trial, maybe that day. I mean, I've had trials that opening arguments were right after lunch and we got a verdict at 5:30. You can do that. So those, you're not going to get much of a break after. But if you've had a long one, a lot of times you're going to need one. And if you work in a place where you don't get it, which a lot of places are, because a lot of DA's offices are way overwhelmed. They don't have enough staff. They're getting slammed. They literally, just wrap your mind around this. They walk into court. Someone hands them a file. They flip through it, and then they try the case right then. Like, that's the way a lot of trials happen.
Like
not months of preparation.
It's like sight reading music, except for the law.
Right. Just wild.
It is wild.
Yeah.
I mean,
that's not our experience.
I will say it is like wind out of my sails after a long trial, though. And by long, I mean more than a couple of weeks, where it just feels like you've been punched in the gut. Like, I always get really sick after a trial. I usually get sick before a trial too. And usually the adrenaline kicks in and I can make it through trial. And then I get very sick after trial. But the thing is, usually don't have the luxury of working on one case. So while you're in that trial, you've like put everything else on the back burner, and there's a lot to do when you get back because you haven't been able to pay attention to the other cases. And so that's just like the reality. Litigation is like, man, it is just nonstop. It's hard to take breaks as a litigator in any area of litigation, whether you're in civil or criminal, because of the nature of kind of external deadlines that are imposed and have real effects on the case.
Yeah. And it's an interesting life. I mean, it can be tough to build a life around. That's why a lot of people do it for a few years and get out of it, get sort of that good experience, and then get out of it because it's really not sustainable if you want to have a life. In a lot of cases, in a lot of places, there are places where it is, but in a lot
There's
of
a
places,
reason why this is my only hobby, this podcast, and my only friend is Brett. I have no time for anything else.
Exactly. Okay. Easier question or more fun question. Not that that wasn't a fun question. That was a good question. Thanks for asking that question. This is from Rochi Cola. Sounds like terrible cola to me. You have to choose a TV or movie lawyer. For instance, Tom Cruise in A Few Good Men, My Cousin Vinny, Harvey Specter, The Good Wife. Who would you choose to get you out of a jam? So, Alice, you've murdered me. You've been charged with it. You got to find a lawyer to get you out of it. Who are you going to hire to get it done?
I wouldn't hire a lawyer at all. Not because
you gotta represent yourself.
Not because I'd represent myself. So I just finished watching Reacher. Have you watched this? I think there's 2 seasons. I just finished watching Reacher, which is based on a book series called The Killing Floor. And it is not like something I would ever watch. It is one of the most intensely gory, violent shows I've ever watched in my life. Reacher is not a lawyer. He pretends to be a lawyer at times to do things that are wildly, outside of the law. But he gets it done when the law can't get it done and other law enforcement can't get it done. And he's just like the fixer, but like, the fixer.
So
And
you
you
would
know
hire
what?
Reacher to kill all the witnesses? Is that
I
what you're
might.
saying?
I might.
I see.
All I'm saying is I've been through the judicial system. And if I killed you, I did it, right? I'm not gonna get off. And so maybe the only path is do what I gotta do, get on a plane and say la vie.
So this is a good point. If you did it, I think you want a loud, sort of bombastic, the kind of like what's his name from the Casey Anthony case, Jose Baez.
Yes.
You want that kind of guy. That's the guy you want if you did it. If you didn't do it, I would say My Cousin Vinny, because we talked about My Cousin Vinny a lot. But the thing about Vinny in My Cousin Vinny, he is one of the few lawyers who wins the case by being a good lawyer, by doing things about thinking about the evidence and seeing where the holes are in witness testimony and using expert testimony expertly. Like, he doesn't do it through like some big speech in the closing argument, which is usually what happens. And the fact of the matter is, a lot of jury professionals and juries will tell you that by the time of closing argument, the case is over. They've already decided. They've heard the evidence and the lawyers talk, and then they go back and they make their decision. You don't actually sway many jurors with some great soaring oratory in your closing as much as we all as lawyers want to believe that that's what happens. But Vinny really picks apart the prosecution case in the way I would like to think we do, Alice. So I'm going to say, if I'm innocent, Vinny, and I guess, Alice, if I'm guilty, I'll take Reacher to just murder everybody involved in the case.
He doesn't need to murder everybody, but he needs to get me out of here because, like, it's not going to go well for me.
There you go. He just break you out and get you to another country or something. All right. Well, that's a great question. Thank you for that one. And keep sending them.
I might get prosecuted if you die.
Yeah. Well, you've made it clear, and you've already thought about how to get away with it. So
I mean,
Reacher, Lillian. Reacher. Take the P off. So, anyway.
That was great. Well, this has been a lot of fun. Thank you guys for hanging with us with the questions and also with this explanation of a 9-0 Supreme Court decision. Many more probably to come. If you have any questions or ideas for legal briefs, we love hearing from you. You can email us at prosecutorspod@gmail.com. Reach out to us on social media, Facebook, Instagram, X, TikTok, at prosecutorspod. And we will maybe get back to you, but we definitely read it. So thank you guys. Before we sign off, Brett, is there anything else you'd like to add?
This has been a pleasure as always, Alice. Love talking about these issues with you. Look forward to talking about more. I'm sure it'll be a boring rest of the year.
Nothing else will happen. March has peaked. We are done with legal news. It'll be just a bunch of constitutional law for the rest of the year. One can hope. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Yay.
Yay.
Okay.
Are you traveling tomorrow? Because we have a call tomorrow if you can make it. I can
I'm gonna
handle
make it.
Okay.
I'm gonna
I
make it.
Okay. Sounds good.
I am traveling, but I will make it. What time is
That's
it?
right. 8:00. Will you be in the car?
No.
Okay. Hopefully it'll be. Hi, puppy. Oh, boy. Oh,
Look at how put out he is.
I know he
He's
is. He's
like,
so
you've
tall.
ignored me this whole time.
No.
Ignore me.
No.
He's a good
Okay.
dog. He's a good
He is a
dog.
good dog. He is a good
Here.
dog.
Come
What a
here.
good puppy.
Come here. No.
No.
Dad. Poor guy.
No. Those are sweet eyes, though.
Yeah. Eat your face off.